cannot be achieved without justice. The inadequacies of the Kenyan justice system, including ignorance of the law, complicated procedures, exorbitant costs, and court distance, among others, are well documented. The importance of ensuring justice is done for the victims of the 2007-2008 post-election violence were underscored by setting up of the Commission of Inquiry into the Post-Election Violence, CPEV. The CPEV released its report on the 15th October 2008. Amongst other measures, the CPEV recommended the setting up of the Special Tribunal for Kenya to prosecute the main perpetrators of the post-election violence. However, the political leadership has failed to set up the proposed tribunal, giving further evidence of the inadequacies of the local judicial system. As a result, it is important that there are alternative justice delivery points at the local level.
Case
Sometimes cases are very difficult, but when you have elders, it's easier to tackle them.
Communities have always resolved justice matters through the Community Justice System, the CJS. The CJS mechanism of delivery justice works well because it emphasizes the restorative principle of justice. The CJS are respected and revered by people and can thus be used to respond to the post-election violence and some historical issues.
CJS atafundisha hawa jinsi kila mtu akona haki zake na ile ujuzi ambaye amepata kule.
CJS educates us on our rights, and conflicting members of the community are able to understand and respect each other's rights and hence reduce conflicts in the community.
In Rwanda, for instance, the system has been used to give redress to survivors of violence and also bring truth, peace, and reconciliation among communities through the Gacaca.
In Rwanda, the government itself realized they had hundreds and thousands of prisoners. I actually visited Rwanda in 2004 and I went to the prison. You know when you have a shop, the village shop where they have shelves? Prisoners were sleeping as like the way you stack bread on shelves. There was no space in the prisons. So the government realized they had a situation on their hands they had to deal with. Then Gacaca comes in. They formalize it and deploy it. It has been able, at a very practical level, to decongest the prisons. But also because the way it has operated at the village level, where it is the villagers themselves, both women and men, victims, who actually sit as judges and spectators in the court, or wherever it is under the tree, it has fostered reconciliation.
Job Mwaura, an assistant program officer of the Legal Resources Foundation Trust, sheds more light on this.
Basically, Gacaca is a court that is inspired by tradition, and it was formed to address historical injustices and specifically issues regarding the 1994 genocide that was conducted in Rwanda. The Gacaca seeks to address the issues through the community. So the community sits, listens to people who've been prosecuted or been accused of conducting the genocide, and then the community itself comes up with a verdict that is acceptable to the whole community.
Charles Baraza of the LRF traces the genesis of the CJS.
The original activity began in 2008 after the post-election violence. We got a distress call from two people. One person called David Chege from an area called Soget, and the other person called a distress call from the Catholic Church Londiani.
Kabla ya CJS, tunajua mambo ya violence ile baada ya uchaguzi. Legal Resources Foundation walitupatia hiyo Land Rover iko hapo. Tukasema tuzunguke Kikeli nzima tuone vile watu wapo. Na tukazunguka, tukaenda mpaka Kuresoi. Wakati wa kurudi, kama tumemaliza shughuli kabisa, hapo junction ya Londiani, sisi na hiyo Land Rover tukapigwa mawe. Mimi mwenyewe ilibidi nikimbie, niingie Land Rover na nikakaa Nairobi 5 months.
So these two parties informed us of the situation in Kipkelion. They said people have started fighting, and actually the reason why they were calling us was for material assistance. So what we did is we felt like these people, as much as they are in that mode, they need some healing as far as reconciliation is concerned and peace building.
The Judicature Act provides for the laws that are applicable in the Kenyan system, and among them is the customary law, which the CJS borrows from. Anne of the LRF gives us more information on this.
The Judicature Act, which is Cap 8 of the laws of Kenya, provides for the hierarchy of laws. It applies the jurisdiction of the courts in Kenya, that is the High Court, the Court of Appeal, and the subordinate courts. And it also discusses the hierarchy of laws. In the context of CJS, as we know, CJS are supposed to be helping people access justice and also alternative dispute resolution. So in terms of whatever decisions the CJS members arrive at, they must be measured against the laws of the land, and also they must apply rules of natural justice. They must also be consistent with morality, such that they can arbitrate in certain cases, and in others the law clearly states that there is no arbitration. A good example, in a case where there is over chicken thief, CJS members can arbitrate on that, but in a sexual offense they cannot arbitrate on that. So basically I can say the statutes of the land keep the CJS committee members in check, because if they go outside that, then they can be liable to prosecution.
Kenya has in the recent past been involved in discussions around the credibility of the Truth, Justice and Reconciliation Commission and the National Cohesion and Integration Commission. Questions have been raised on their integrity and hence casting doubt on their ability to engage the citizenry objectively.
And in Garbatula, I think the entire district of Garbatula, there exists no formal justice system at all. So the community actually entirely relies on the community justice system as an alternative way of, dispensing community justice.
Being national organs, the Commission has yet to engage the communities in the grassroots. Meanwhile, the communities continue to suffer from the injustices caused by the imbalance in the political environment. Kipkelion is one of the constituencies vastly affected by the 2007-2008 post-election violence.
As you can see behind me, this is Ngirimori Center, Chilchila Division in Kipkelion District in the Rift Valley Province. And behind me there is what was caused by the post-election violence. This used to be business premises, and they belonged to almost one community. They were all destroyed.
In the aftermath, the violence has created a lot of suspicion among the different communities living in the constituency.
Sisi hapa Londiani tunaishi communities tofauti. Na nimekaa
In Londiani, we have different communities.
between our communities.
I think we should have exchange programs between these communities.
Tukienda kwetu pekee kama ni Kalenjin.
The Kikuyus and the Kalenjins should have exchange programs so that we can learn from each other.
The constituency has a history of ethnic clashes as a result of suspicion between the different communities and are also fueled by politicians inciting the different communities against each other.
Kitoa mwito wangu kwa ukazi wa Londiani, ningewahakikishia ni vizuri tukae na amani.
I will urge the residents of Londiani to live in peace and not to be misused by politicians.
Hata wanasiasa wanakula pamoja, na hakuna siku wanasiasa watakubali kutoa watoto wao.
The politicians will never allow their children to be in the front line of clashes.
Sisi wenyeji ambao tunaishi hapa.
Let us vote wisely and not allow politicians to misuse us.
The constituency has 7 divisions, namely Kunyak, Chilchila, Chepsion, Londiani, Kamasian, Kipkelion, and Soget. Their peaceful coexistence, though constantly disrupted, needs to be rebuilt. LRF introduced the CJS concept as a way of promoting dialogue among community members.
I want to thank LRF for training CJS members who are now able to reach out to the community. Previously, it was difficult to get efficient services from the local administration.
The concept seeks to blend and strengthen positive elements of the indigenous communities' cultural practices and the legal framework to bring out justice, peace, and harmony in the community. The CJS is composed of different communities living in Kipkelion who also have different background in relation to training and career, age groups, religion, and gender. The CJS complement the role of the local administration in assisting in dispute resolution. Its function is advocacy in the community on justice, peace, and harmony in the community. It seeks to address the injustices of the community by looking for local solutions to cases of human rights violations and addresses intertribal violence in the community.
Na nyumba ingine nilikuwa nataka kunyakua shamba kutoka kwa nyumba hizo kwa nyumba ingine. So wakaenda kustaka.
Two community members were fighting over land and took their case to the DC's office, but the case was brought back to us. We took 3 weeks to resolve the matter amicably in accordance to their dad's wishes, and the two have now been reconciled.
Legal Resources Foundation has trained 143 residents of Kipkelion constituency as CJS members so that they can assist in solving disputes and promoting reconciliation in the community. They have been trained in peace and reconciliation, gender-based violence, conflict management and resolution, and human rights. These were volunteers with an interest on human rights and who were elected by members of their community. Baraza of LRF gives us more information on the Kipkelion project and cites the challenges encountered in setting up of the CJS in Kipkelion constituency.
The area has 2 police stations. Reporting of cases that are supposed to be reported to police stations are not done so because of either the distance of the police stations or maybe the police stations are not well equipped. Secondly, some provincial administration members have not embraced the culture of human rights principles. We have areas like Kokwet in a division called Chilchila, which is quite remote. The provincial administration members are still practicing some of these cultural practices that hinder the development of human rights. Women still in some divisions do not clearly speak or they don't come forth. And lastly, maybe I can say the partners that you are working with in Kipkelion. We have some international organizations who come to work with us, but on a short-term basis.
LRF recognizes the important role the local administration plays in peace and reconciliation.
Mimi tunataka kushukuru LRF sababu ya kuanzisha hii program ambayo imetusaidia sana. Kazi yetu saa zingine inakuwa ngumu sababu ina involve mambo mengi. Na wakati
Since CJS was formed, we have found it easier to work. For example, in a recent dispute, I would have been forced to take the matter to the police. And you all know that once an exhibit is recorded at the courts, it takes a while before one gets it back. As I was thinking about it, I was informed that the matter has been settled.
Among the members of the CJS are councillors, chiefs, and police officers. CJS members are recognized in the community as resource for justice and hence referrals from the community and also from the administration. The different communities are able to sit together in different forums with an aim of building peace in the community.
Kwa hatua ambayo umechukua wakati uliambiwa kuna mkutano hapa hivi wa LRF, ni vizuri kwa sababu umekuja
Thank you for coming to Legal Resources Foundation meeting. You have all heard that there are only 20 CJS members in Kunyak. It will be important if all of us took this message to the rest of the community. Then we shall have more CJS members.
Lipale of the Legal Resources Foundation gives us an insight as to how community peace building system operates.
So through the CJS, in our own terms, the communities are able to come together. The warring groups or the group that are in conflict, the accused and the accuser, on that note, are brought together through this forum called CJS. And under the forum, as we have seen in Kipkelion, you know, the different groups come together and air their views. They will talk, say their issues, talk openly. And then we have these communities that we call them a neutral group, who act like judges in the formal setup. And through that, issues are resolved. And one good thing about this approach is that resolutions that arrived are actually acceptable across board. Yeah, because everybody in that forum is allowed to talk. There is no discrimination. Even the gender issues are not really a problem, because here everybody is allowed to talk in an open and fair manner. So at the end of it all, any resolution, everybody would have contributed to it.
Further, the use of CJS has also adopted in communities in Lodwar in the implementation and piloting of the Small Claims Court. Community elders are elected in various villages and together with the chief or assistant chief preside over petty matters that revolve around personal law and petty crimes. Janet Munyoki elaborates on the relationship between the Small Claims Court and the community justice system.
The idea behind the community justice system is there to provide an access, a special kind of access to justice for people that are not able to either legally go to court, to the formal courts, to access justice from there. Therefore, the Small Claims Court is a version of the community justice systems because the procedures are very liberal. We do not have, it is not as tedious as you'd find in the other courts. Most of the times cases are conducted in the customary way of doing things. Decisions are localized and accepted by the community. Therefore, community justice system and small claims courts are one and the same thing. It's just that the small claims court is more inclined to civil claims. In community justice systems, you'll find they will also attempt to deal with criminal matters, although to a very small extent, because there's now that technicality when it comes to handling criminal matters vis-a-vis the existing law.
They are assisted by community paralegals who act as the legal resource to guide the court to arrive at decisions that are in conformity with the law. CJS has different dimensions. Some of the experts share their thoughts on CJS.
So these justice systems, which in a community where women play an important role, exclude women, that must be repugnant to our own sense of justice, so they cannot be allowed.
We have faced a number of challenges when it comes to using the community justice system as a means of conflict resolution. Number one is that the people themselves will tend to use customary law to the larger extent, and we all know that some of these customary laws are quite retrogressive. So to try and intertwine customary law and the formal law has been a little bit of a challenge, because most people are not quite receptive to the formal justice system, which they say is too foreign. They want to use customary law, even in matters that you will consider too criminal to use a customary law, for instance, in cases of murder and sexual offences.
In terms of the kind of support maybe that we try to do, we have a number of civil society organizations like the Isiolo Human Rights Network, Action Aid, Kenyan National Human Rights Commission, Legal Reform LRF, which from time to time has also been in touch with us. And through this, we are trying to build, the community justice system as the only alternative actually to dispensing justice within the entire Garbatula district.
Community justice systems are very valid. And this is because these are structures that have been used over a long period of time. They are structures that are still being used, taking into consideration the distances between the people and the state institutions. So they are very useful in this regard, and they can actually not be done away with. In fact, it's about time that they are included in the institutions or in the government institutions.
There are several challenges which face the implementation of CJS. Firstly, there is political interference in peace and reconciliation efforts in the community. The national processes in the political arena impact on the fragile environment in the community. Secondly, limited resources to train and facilitate the CJS in the community undermine the efficacy of the system. Isaac Opicho, the finance officer, elaborates on the financial dimensions of this project.
Resources are actually the backbone of our operations, basically. And remembering even from this CJS program alone, we did have quite a huge budget in terms of the number of participants we wanted to invite, which already is a challenge to us because it means we cannot be able to achieve our targets. And what I think is that we would require to do a lot of project proposals in terms of sustaining this project and sustaining the CJS systems countrywide, and even the replication of this program to other areas.
Despite the fact that there is a provision for alternative dispute resolution in the formal system, this has not been decentralized and hence poses a challenge to streamline this initiative. Jedida Wakonyo, Executive Director of the Legal Resources Foundation Trust, is very optimistic about the future of the CJS program and the value it adds to the Kenyan justice system.
The Kenya National Commission on Human Rights, in its publication On the Brink of the Precipice, where they did a human rights account on what happened during the post-election violence, they vividly elaborate the situation that the people of Kipkelion experienced in terms of the conflict, in terms of the human rights violation. And therefore, when we advocate for the community justice system vis-a-vis the post-election violence, what we are saying is this: there is a space for the International Criminal Court to deal with the serious human rights violations, crimes against humanity. There is an opportunity for us in this country to establish a special tribunal to deal with the other human rights violations that existed. And then there's the third level, where there are those cases that do not need to go and clog our criminal justice system, that need to be resolved at the community justice system, at the community justice level. And these are the small petty cases that will provide an opportunity for this country, for Kenyans to be able to reconcile, to be able to reconstruct, and to be able to move on from where they are. But if we leave everything at the International Criminal Court or the special tribunal that we are yet to establish in this country, if we leave them at those two levels, reconciliation, reconstruction at the community level. Remember, people are neighbors. People still will need to continue living together. We have to approach it differently, using the community justice systems that have a restorative approach, which is very essential in this country.
The proposed constitution has a provision for the establishment of traditional courts, so long as they are not inconsistent with human rights and the constitution. This is the first pillar in establishing these courts, which will enhance access to justice in an effective and efficient manner.
God of all creation, bless this land and nation. Justice be your shield and defender. May we dwell in unity, peace and liberty. Plenty be found